Welcome. My name is Paul Hitchcock, and I'm a colleague with Harry Barth, who is the founder and senior managing partner of Barth Calderon in Southern California, an asset protection, estate planning, business planning firm. Harry's a Vistage member, top Vistage speaker, has over his career traveled around the country, giving many workshops. And this topic we're talking about today, the Corporate Transparency Act, is a very hot one. So a lot of detail. It's going to be very useful for you. Take notes with a lot of takeaways on what Harry will be talking about. Michael Edwards is Vistage Chair. And Michael, thanks for partnering with Harry and myself on this. I know you've got your thumb on the pulse of issues that impact your network and the CEOs you're dealing with. And so, yeah. And so before we get into Harry's talk here, Michael, if you could kind of introduce yourself and what you're doing there with Vistage and what you're focused on.
Yeah, thank you. Thank you, Paul. Harry, nice to see you again. I am a chair for Vistage Worldwide. I live in Lincoln, Nebraska. And some background, Vistage is the oldest and largest CEO coaching and leadership development firm in the world. It has over 45,000 active members in 35 countries. And it does things a little bit different in the coaching world. It is a prime believer and advocate of peer coaching in groups. I have two groups. One is for CEOs. And my members range from about 10 million in revenues to 620 million in annual revenues. And I also have a trusted advisor group, which is for professional service providers like bankers, attorneys, wealth managers, and the like. I've talked about the Corporate Transparency Act in my groups. Some knew what it was, some didn't. And I told them there are some exemptions, but like any good law, there are exceptions to exemptions, and that's where it gets really tricky. So this is a very timely event, I think, for both my members and other folks who are tuning in, and it should be extremely helpful.
Wonderful, Michael. Awesome. Harry, you want to take it away?
Sure. Well, good to be here, Michael, Paul, and we have a lot to talk about in the hour that we have. And hopefully we'll kind of lift the veil a little bit about what the Corporate Transparency Act, we'll kind of make it a little bit more transparent than it is to the general public. A lot of people, surprisingly, don't know about it. So first, some definitions. So first, you're going to hear a lot about the words FinCEN. FinCEN is the Financial Crimes Enforcement Network. It is a division of the United States Department of Treasury, and they are the governmental agency that has been tasked with putting together and enforcing the Corporate Transparency Act. It's important to know that when we talk about constitutionality of the act, it is bipartisan legislation that happened back in 2021, but not being implemented until 2024. Purpose. The purpose of the act is critical because as we go through things together today, if we understand the purpose, we'll understand the task that's in front of us. The purpose is to find the human beings behind all of the limited liability companies, limited partnerships, and corporations. Not the big ones now, but the small ones. This is targeted for small business. And reason they want to know is XYZ LLC. Who owns it? Who are the humans behind it? Because since 9/11, the government or various different governments around the world have been trying to track terrorist financial activities, money laundering, and the use of shell and shelf companies for various different nefarious activities. So that's the reason behind where we're going, and it becomes very important as we begin to look at the specifics of the act. So who's impacted? Well, you got two, we're going to draw a line for new entities that are formed like after January 1st, 2024, and then all of the existing entities that exist prior to all of the existing entities that exist prior to January 1st, 2024, the best estimate is the impacted entities in America, 35 million of them. And those 35 million need to come into compliance under the current law by December 31st, 2024. For new entities, they have to come into compliance within 90 days of the time that they give birth. Now let's talk about giving birth. So first of all, a corporation, a limited liability, a limited partnership, a limited liability partnership, all of those tools that we all use in asset protection, business structures, and estate planning. When we have to go to the Secretary of State in Nebraska and say, hey, look, we want to form an LLC. So any entity that has to be formed in the state, you get a state, certificate that you are good to go, become a legal person, is an entity that is required to be a reporting entity under the Act unless there is an exemption. And we'll go through the exemptions in a moment. So let's talk about this, because a lot of scuttlebutt about this, about the constitutionality of this Act. It's quite intrusive. There are a lot of factors. There's a lawsuit moving through the federal system. It's the National Small Business Association, I think, versus the United States, to have the Corporate Transparency Act declared unconstitutional. Now, I have 50 years of experience, and my best opinion is that it is not going to be declared unconstitutional at the end of the day, but parts of it may be declared unconstitutional. What parts? Well, there are some pretty egregious penalties for not complying. So if we don't comply by the deadlines that are set by Congress right now under the law, Mike, $500 a day fine up to 30 days. So that's $15,000, $500 a day. Then there are criminal fines of $10,000 and up to 2 years imprisonment for willfully not complying under the Act. They're dead serious about this. And surprisingly, it's the FinCEN network, the Financial Crimes Enforcement Network. And the database that they're building is allegedly not going to be public. There are very serious consequences for releasing any information that was gathered by the government. And we saw just recently an IRS whistleblower just got nailed with 5 years in prison for releasing information that they should not have released. This is kind of also very, very well protected.
It's a felony, Harry?
Yeah, it's felony to willfully not comply. They're very serious about this. So what we're going to do, first we'll talk about a little bit. So those are the entities that are involved. So as you can see, one entity that I haven't talked about is a trust. A trust, your family trust, all the trusts that we do for estate planning, asset protection trust, all those trusts that we have. At this moment, trusts themselves are not reporting entities under the Act because they don't get filed with the state. So they're still out there. And by the way, an option for doing things that do not have to have a governmental registration. But as you'll see as we go through this together, they are impacted significantly by the Corporate Transparency Act. All right, so we got it. Limited partnerships, limited liability companies, corporations, you name it. We're going to turn around and talk about whether or not they are forced to comply. So first of all, let's go through, I think really great, the exemptions. If you fall to one of these 23 exemptions, you do not have to comply with the Corporate Transparency Act. So let's go public companies. Big old anyone's listed on a NASDAQ, American Stock Exchange, New York Stock Exchange. If you're a public company, the SEC has given you enough of a financial colonoscopy that they know who the people are, and so therefore they don't need to comply. SEC registered investment advisors are exempt. Why? Because the SEC has given all of the investment advisors a financial colonoscopy, and they know who they are. They've been fingerprinted. They've been background checked. They know the individuals that are investment advisors. Venture capital funds are the same. Insurance companies and insurance producers, you get the idea. If it's licensed and it's from the state and the state has run background checks, we know who you are, you don't need to comply. Certain other highly regulated industries, so banks, credit unions, registered securities brokers and dealers, trust companies themselves don't need to comply. Public accounting firms, CPA firms that are registered to do Sarbanes-Oxley audit work do not need to comply. But it's also important, while I'm there for a second, just to take a pause, that the AICPA, which is the national CPA organization, is kind of put out a warning to their members saying, hey, look, giving people counsel on how the Corporate Transparency Act works for your company is a provision of legal advice. So you might be engaged in the unauthorized practice of law. So it is better. This is not an advertisement now for lawyers, but it may be better when we're analyzing this to do it with a law firm. There's attorney-client privilege, and there are a lot of legal principles that we're going to get into that you'll see that there's probably no organization better than a law firm that engages in business transactions, asset protection, estate planning, such as our firm. Then you have all of the political organizations, tax-exempt organizations. Charities are exempt from the act. Government authorities, of course, they're exempt from the act because they're the government. And subsidiaries, and we'll talk more about that, of an exempt entity are exempt from the act. But Mike, in your case, and for many of the people, there is one other exception that is important, and that it's for most Vistage members and other companies who are exempt. Remember, this is targeted for small companies. So there is another exemption, and here's what it is. And this is an and, not an or. So if you have 20 or more full-time employees, as defined by state law, and your office is in the United States, headquarters in the United States of America, and you have over $5 million of gross sales. You have all three of them. You have a headquarters in the US of A, 20 or more full-time employees, and $5 million more of gross sales. That entity is an exempt entity and doesn't need to report. And as you described, most of the Vistage members fall within that category. But it doesn't mean that they're not reporting. They may not be reporting on the mothership, but as you'll find, many of your members and many of us, like I have, my law firm is an exempt entity. We have over 20 employees, over 5 million gross. We're headquartered in the United States. But I have 9 other entities that hold real estate securities, venture capital shares, things of that. All of those need to comply. So if a subsidiary of the law firm, if the law firm is exempt, the subsidiary is exempt. So you have a firm, they make widgets. All right. They're over 20, over 5 million, and they have 3 subsidiaries that are wholly owned by the parent. Those subsidiaries are exempt. But good protection tells us that it'd be better to have a brother-sister organization rather than a parent-child organization. And usually those brother or sisters need to report. Okay. So there are the exemptions in general, and the types of entities. So once it's determined that we have an entity, and I'm going to take us through the birth of a new entity in Nebraska. So we're going to form Harry Paul Michael Co., all right, an LLC known as Widgets Are Us in the state of Nebraska. And we're going to do that in February of 2024. So first of all, are we a reporting entity? So the answer is yes, we are. So if we are a new entity from the date that the state of Nebraska says, Harry Paul Michael Co., you're born, here's your certificate of organization for our LLC, we have 90 days to register and complete all the verifications needed for the Corporate Transparency Act for our entity. So we'll start, and the entity, it's not us, the entity becomes the thing that is the reporting responsibility, the entity. So we have this entity we formed. And so what we got to do? So we got to register the entity. So what do we got to, what info do we got to give the gov? All right. So we got to give them the name of our company. So our legal name is Harry Paul Michael Co., LLC. We got to give them that and all our DPAs. So if we got a DBA known as Widgets Are Us, we have to give all the, how we're doing business as, all of our names. So We got to do that. We have to give them the physical address of our company, where our headquarters are. It can't be the lawyer's office, which was typically done. Can't be the accountant's office. Can't be a UPS box. Can't be a PO box. It needs to have the physical address of that company. And we need to give a specific taxpayer or a specific identifying number for that company. So when we formed our company, we went to the IRS, we got an EIN number. So that EIN number. So we take all that information and we send that off to FinCEN, Mike, and now we have our reporting company. If we are a single member LLC, sometimes people will know those are also known as disregarded entities for federal tax purposes. And so some people will get an EIN number for convenience, so we can use that number. If not, they need to use their social security number as their specific taxpayer identification number to get our company ready to go. Now, so it begins. But you see, the Corporate Transparency Act, and they talk about beneficial owners. First of all, it's not just corporations, it's LLCs, it's limited partnerships, it's limited liability partnerships. Let's talk about what we have to do. So for new entities formed after January 1st, 2024, we have a section which is called the company applicant. So if you, Mike, we formed this in my office, in my law firm, and we have my paralegal that filed the papers with the state of Nebraska. So my paralegal, needs to say that she is the company applicant, her name, and her FinCEN identifying number. She filed the paperwork on behalf of our entity. And if I am the lawyer that recommended us to create this LLC, I also must report as the supervising attorney and company applicant. So we have the company applicant, the lawyer, and the actual filer that needs to be reported to the Financial Crimes Enforcement Network. For the pre-existing entities, all the 33 million of them, prior to January 1st, 2024, where we have the year to report, we don't need to have a company. We would never know who the paralegal was. We would never know who the lawyer was. They could be long dead, gone, and incapacitated. My God. So at least we don't need that for them. So that's the entity. Now we have the next spot. We now need to report or discover and display who owns the company, right? And that's really important. So if you own more than 20, we need to report. So in Harry, Paul, Michael Co. LLC, Harry's got a third, Paul's got a third, Michael's got a third. We're all over 25%. We're not minors. Minors don't need to report, but the parents of minors need to report. We are now have to report as what they call beneficial owners. So what do you got to send, Michael? So you got to say, okay, I own 33 1/3% of company. And so here's my name, my full legal name. Here is my home address. You want your home address. They don't, again, no post office boxes, UPS boxes, no attorney's office, no CPA's offices, your home address. And here is a color copy in the form of a PDF of an unexpired passport or an unexpired driver's license in the state of Nebraska. So we got to send that in for your 33 1/3 as a beneficial owner of that company. Now, if you went online, which you should, and got a FinCEN number, you've already uploaded that information, and the Treasury has issued, FinCEN has issued you this number. We would just put down Michael Edwards owns a third, FinCEN number 0001234123445. So we don't have to repeat your home address and your driver's license every single time Michael Edwards has a reporting requirement. But you see, the government is not very clear about this thing because there's a second part. It's not only the ownership of anyone that owns over 25%, and we'll come back to trust in a moment. It's also who controls. So controlling interests have to report. So in our LLC that we form, we have, let's say, a manager of that LLC. And just for craps and giggles for today's meeting, Let's make that manager of that LLC, not us, but a corporation. All right. ABC Co. Management company we hired to be the manager of our LLC. So they don't have any ownership interest. They're not beneficial owners, but they control the LLC. So we now need to report, the company has an obligation to report all of the C-suite CEOs in that company. So the president, COO, the CEO, perhaps the CFO, maybe the CIO, maybe the CTO, a lot of C's, okay? If they have enough influence that we would say around the control and movement of assets, they all need to report. And if that corporation has a board of directors, all right, that as a not an advisory board like Vistage, but a real live board of directors, and those board of directors have the ability to remove and replace the C-suite executives, then every member of the board needs to report as well. Oh boy, this got really complicated real quick on control. But control could also be in a voting trust, so it needs to report. Control could perhaps vest in an ESOP. It needs to report. So you have control. We could have a scenario where we have a corporation, a limited partnership, or an LLC, where the three of us own 99% non-voting, all right? And then, Joe Blow or Jill Doe owns 1% voting, so they have control. They need to report. They're not at 25% ownership, but they have a control factor that's involved. So you have to analyze very carefully the control of our entity. Now, of course, when we're creating new ones, Mike, in 2024, we as the lawyers, we kind of know, we set it up. We know who's the controlling people and we know the information to get. But we go back to 33 million companies. Oh my God. Trying to figure out who's in control sometimes could be a magnanimous task. And that's why we have a little while to do it. And there are no exceptions here. Maybe you said exceptions to the exemptions. If the picture's not complete, you can't even submit it, or FinCEN is not even allowed to look at it. Ugh. All right. So let me go on a little further. So I was speaking with the Vistage chair. We were talking the other day. We were doing a workshop similar to this in Texas. He said, a lot of my members are in the oil and gas business. I said, of course, everybody in Texas in the oil and gas business. And so we turned around and said, what, how they do it is they usually form an LLC when they drill a well. Every well is its own LLC because if the well blows up and, they call it a blowout, have all kinds of liability. They want to confine it to that one LLC. So that one LLC is now a reporting entity. It doesn't have that now 5 million, no 20 employees. It's a reporting entity for that one LLC that's drilling an oil well. And he says, usually 4 or 5 guys or gals get together and invest in that oil well. They do it. They invest in the oil well. And usually those are LLCs. So there are 5 LLCs that own the one LLC that's drilling a well. Every one of those 5 LLCs is a reporting entity. Now, some of those LLCs are held by holding companies. It's over 25%. The holding company is a reporting entity, and then the holding company may wind up in a trust. So that gets us to this next spot that I want to go to. So Michael's talking to Harry, and we have, Harry Paul, Michael Co. LLC, and say, okay, well, how should I take title to my 1/3 interest in the company? Well, and it belongs in your living revocable trust that you've done for estate planning for the family to avoid probate, to avoid surrogate court. So it follows the game plan with privacy. We know that most assets belong in a trust. That's the proper way to do planning. So now, Michael, you are no longer the owner of that 1/3. Edwards Family Trust is the owner of that 1/3. So now, who are the trustees? Michael and his wife. They need to report. Who are the beneficiaries? Well, right now it might be Michael and wife. All right. So they need to report as beneficiaries. If we have 3 kids as beneficiaries and they're over the age of 18, we look through the trust and they need to report. Then we might have an outside trustee, they need to report. And if you have the ability to move assets in and out of the trust, which you do almost universally in most trusts, the settler or the creators of the trust, you and your spouse, need to report yet again as the settlers of the trust. So it is possible to have close to 30 to 40 reporting entities on what's seemingly a relatively simple subject matter. But it gets another thing that we need to be concerned about. So this is the lattice work for new entities. It's the same exact lattice work for older entities that are in existence. You got a question, Mike, coming up or no? Okay,
No.
let me continue.
No, we're good.
Okay, so let's continue on. So what else needs to be done with this? Well, you got to have, so every LLC we know should have an operating agreement, which lays down all the rules, regulations. They all need to be modified. Why? Because a new section needs to be added called Corporate Transparency Act reporting. And it basically says that if you're going to be a member of an LLC, our LLC, so let's say we want to bring in a 4th member to Harry, Paul, Michael Co. Want to bring in, Joe Blow as a member. They all have to agree to comply with the Corporate Transparency Act. If they don't agree to comply, well, I'm not giving my information. I don't trust the government. They cannot be a member in our LLC because they would force our organization to be out of compliance. We'd have a 4th member. There's no excuses. If there are 4 owners and they're each at 25%, they have to report. Now, sometimes that gets a little challenging because over the years, companies, corporations were owned by some of your members, some of your CEOs, and some of us. And there was a divorce 15 years ago. And the spouse, who you haven't talked to in 15 years, may have ownership interest in a company that's held in a trust with her new husband. They need to report. Oh my God. There's no exception. So you now figure out, how do I get to do this? I have to get these people from 15 years ago. I may not even know who they are. They may have transferred their interest to a child. All right. It may not have been up to date on the corporate books and records. So we need to do an inventory or a challenge on that until we get it right. So shareholders agreements and operating agreements need to be revised and have corporate transparency language that is built into it. Now, moving through Congress right now, signed by the House, passed by the House, not yet passed by the Senate, and not yet signed by good old Joe, is a new bill revising some aspects of the Corporate Transparency Act. What are those? The new one? Well, the major one that's in the bill, and these are mostly about timelines and extensions. I don't know how on earth we're going to register 33 million companies, go through that analysis for each of those companies and get them filed on the government website before December 31st, 2024, when the penalties begin on January 1st, 2025. So the bill changes that and changes the reporting to December 31st, 2025, giving us 2 years to deal with the 33 million. I think we need that, but it's not law yet. The other change that they have, which is a welcome change, is that changes right now. So you live in Nebraska. Let's say you decide to move to Oklahoma. And today in the remote world, people are living all over the place, moving and challenging and doing it more mobile than ever before. So your address has changed and your driver's license may change. So whenever we have a change in the name of the company, change in ownership, all right, so Michael went out and Joe Smith took over your 1/3. We now have under the law only 30 days to report changes. That's really a short fuse to report a change. Otherwise, we're not in compliance. So the new law extends for changes to 90 days. So that'll give us 90 days from the time there's a change to get it reported over to FinCEN. But there's another aspect of that law. There's the old carrot and stick when it comes to the government. And the other aspect of modified law, which is not yet law, is the one that I was talking about earlier, where it instructs the Financial Crimes Enforcement Network that it cannot look at or accept anything where there's an exception. There are no exceptions. Every human being that's involved in a reporting company, we need to know who they are. We need their driver's license. We need their home address. If you're missing one, your company will not be in compliance. There's not a place mark there. You get an exception. You have to either find who they are, get that information, buy them out of the company, get rid of them, whatever it may be, so that company could be in compliance. Otherwise, there are fines. And I think they're also baking in fines for the people that are being defiant. So fines and or jail time for someone who's causing Harry, Paul, Michael Co. not to be able to comply. So one of the things that we see, as I talked about earlier, is that in like with most of your constituency and myself, maybe their main company is exempt. Many of the 20 employees, 5 million gross sales. And if it has subsidiaries, a subsidiary for equipment, subsidiary for intellectual property, a subsidiary for real property, if that subsidiary is 100% owned, then the subsidiary is also exempt. But that's not the way to do it. So what happens is that you have the OpCo, and then we have, the real estate owned in an LLC that's owned by the three of us, and we lease that real estate to the company. That is not an exempt asset. That real estate company is a reporting entity. It's like I said, it's brother and sister to us or to us personally, and not parent and child.
Harry, when you're doing asset protection planning, is that a common strategy for you as the brother sister versus the parent?
You always would rather have brother sister than parent subsidiary for reasons that are well beyond today's seminar. But from an asset protection perspective, it's better. Assuming tax-wise, we could do it in every other way. If we have a foreign company, all right, a Nevis LLC, a Cook Islands LLC, an LLC that was formed in the British Virgin Islands, and they're doing business in the United States, the foreign entity also, if it's doing business in the United States, must comply. Same thing. Who are the human owners, especially? Where do they live? And an upload of their governmental or whoever the owner's driver's license and or passport. Another thing that comes about, Michael, is that I'm sure as we're talking about this, you think about this, is that there's an awful lot of sensitive information that's going to be floating around that's being transmitted from computers to the government back to us, to law firms, to the government. So all of a sudden, I think that you have a very important responsibility, because for people that would love to hack into those transactions, because if I could get, your disregard, I get your social security number, where you live, I get everything about you, I get a copy of driver's license. If I could pick up that information, that's awful. So we have to make sure that when we're dealing with this in an attempt to comply, that we have appropriate security, confidentiality, appropriate vaults that are involved, encrypted data that is moving around, so we don't have bad actors and bad players to do it. Now, personal couple of notes about the case of constitutionality. This is, for a lot of people, Michael, this is pretty intrusive. They are not happy. All right. Well, so there's a burden. There's a cost, all right, of compliance. Most people will use a filing service like we have, or most people will have their attorney analyze the company to see how it needs to be brought into compliance and who needs to comply. Not an easy analysis. Sometimes it's easy, sometimes it's very, very complicated. So there's a cost. It takes time. So you have a burden. Aspects of the law are still unclear. You have a lot of things that we just don't know the answers to yet, and that's not good. When you have a law that's so difficult to comply with, that's no good. And the other thing too, probably more than anything else, if you don't do it, there's criminality, it becomes a crime. Not so sure that part will remain constitutional. I could see a fine. I mean, it's kind of like if you don't pay your taxes on time, they fine you. There's interest penalties, things that they don't put you in jail, you know, for failure to have an appropriate or proper tax return. Here, they won't put you in jail. I'm not so sure that will survive constitutionality. And the other thing too, when I studied the case that's moving through the court system, there was one overriding factor that I'd like to share with everybody, and that overriding factor is the goal of the legislation is to get the bad guys, to discover the bad guys, to say they can't use these shell companies or shelf companies. I think the Bidens had like 18 shell or shelf companies or other people. Started with the Pandora Papers, down in Panama. All these people were hiding behind LLCs, limited partnerships, layers and veils along the way. So you don't know who the heck is transferring money anywhere to get it done. And I think that what they're going for is noble. They've been trying to do it since 9/11, Patriot Act, know your client. We go to get a loan, go to the bank. They want to know everything about you. They'll get your driver's license. They'll get your thumbprints. You just simple notary. They want to have your address, driver's license, sometimes thumbprints. So that's going to be there. But the question is, will this stop the nefarious activity? In my opinion, the answer is no. In my opinion, this will take 33 million legitimate, viable, good businesses, put them through the ringer to make sure that they're in compliance, and the bad guys are going to find a way around it anyway. So the bad guys will still find a way to finance terrorism and launder money. Maybe a little bit more difficult now with the Corporate Transparency Act, but at the end of the day, they'll create fictitious human beings if they have to, in order to accomplish their goals and their objectives. So I think the burden is very strong, and I think the benefit is maybe not there. And that may be a reason for unconstitutionality along the way. So there you have inherently what the Corporate Transparency Act is about, and why it's being done. And its goals are noble, but we'll see how it all works out. But at this point, Mike, I think it's important for people to understand that a lot of people are saying, well, let's wait and see what happens. All right. I have until December to file. I don't think that that's smart. New companies where we have 90 days and we form new companies, we bring them into compliance where we give birth to them or craft them. But in the other ones, I think the sooner the better that we get into compliance with them. But the other thing also that's very important to understand, a lot of people miss this is one and done. Once we file Harry, Paul, Michael Co. LLC, we're done. It's not an annual filing. There's no annual fees associated with it. We paid, maybe an extra $400 to bring it into to determine who has to file, and maybe a couple $100 to file it to save you from going into that Byzantine government website and trying to figure that out. We could take care of that for you, but I think it's important to understand it's one and done. So absent changes, all right, we don't think else we have to do. But if Paul, you get hit by a bus, and now your ownership interest moves from, and by the way, before you got hit by a bus, Paul lives in California. California is a community property state. So Paul and his wife are the owners of his 33 1/3 interest. Both of you need to file. And then if the two of them get hit by a bus and it goes to a trust to your children, that's a change within 30 days. It needs to file, and so on and so forth. So it's a constant thing, but it's only once a year. And with that, I will kind of wrap up a little bit what I have to say. And if we have questions and answers, or Mike, you have questions, I'll be more than happy to answer them. I think it's a pretty detailed summary of what has to happen. Beneficial, I'll just repeat it one time. We got to register the company if it's not exempt. We then have to register all the beneficial owners. We have to then determine who are the beneficial owners, and the one that's the sneaky one, who's in control. You can have 99%, like I said, non-voting shares, 1% voting shares. The 1% voting shares are in control, but they don't own 25%. So it's a control and ownership structure, and that trusts are implicated by the ownership of the beneficial interest. So the trust has to report, but the trust itself is not a reporting entity. Okay, any questions?
I don't have any questions, but a couple of things do occur to me.
Sure.
You mentioned 33 million potential reporting entities.
Yeah, 33 million, yeah.
When you add in those individuals or entities that are required to report on behalf of those 33 million, it occurs to me that the actual number of required reporters is not knowable.
Correct. It could be 250 million, yeah.
Yeah, it's just huge. One of my members has in excess of 600 million in annual revenues, owns about 55 stores, a couple of manufacturing companies. These are in 7 or 8 different states. They're owned by an ESOP. There's this, I know them well enough to know that they're working on this, but it's going to be complicated for them.
Yeah, maybe.
Maybe.
Most of those, most anyway, entities, if they're subsidiaries, remember, you got to go back to the mothership.
Mhm.
And in the mothership, if it has, usually if it's more than 20 employees, especially if it's an ESOP, and more than $5 million of gross sales, so they're exempt. They
Yeah.
probably don't have to report. And the manufacturing facilities probably have separate companies, probably have the 20 and 5. So a lot of them fall under that 25. This is really targeted to, they have that one piece of real estate. One piece of real estate, the building that they're working is worth 40 million bucks. All right. And it's owned by the owners. That's a reporting entity. But the mothership itself, the OpCo, may not be a reporting entity. But yes, you have to analyze each of those silos and report it properly. And there's a little window. We have 30 days in the time that we report it if an after discovered fact is not right to make a modification on FinCEN without penalty. And I could share with you, having done this for so long with dealing with the IRS and penalties, where they, it's the word that's important here is that they utilize in order to get into the criminal aspects of this. It's willful. All right, not negligent or we didn't know. All right, it's willful. Like I know, and I am not reporting. I am not telling them what they want to hear. That's willful. That's when you get into all that other stuff. The fact that they may have missed a reporter along the way or missed a controlling person along the way, negligent, we'll correct it when we discover it, probably be okay. Could they fine us for doing that? Yeah, but traditionally they don't. At least not the first time. But after the first time, they're not quite as forgiving.
Yeah, one thing that occurs to me when you and I first talked about this, and we talked about the primary exemption being the size and the revenue base, I wondered why the federal government set it at what I consider to be fairly low levels. Is that because they're looking for small terrorists who launder money, or is there
Yeah,
some? I know
well,
that the
yeah,
5 million is a magic thing in a lot of other laws.
yeah. I can answer that question for you. So why the and? Remember, it's not one or the
Yeah.
other. It's the and. Vast majority of companies that were used for nefarious goals and activities did not have 20 full-time employees.
Mhm.
They had virtually no employees.
Okay.
Maybe one employee. So we catch that one there. And then the other one is the 5 million of gross sales. So when they're moving around assets, laundering money, moving assets, you don't see sales. You just see movement of assets. So the target is, could there be a terrorist organization using a manufacturing plant as a front that has 50 employees and $30 million of gross sales, sure. But that's not the usual. The usual is, let's just form a company, and we'll form a company in Wyoming. I mean, LLC in Wyoming. Wyoming doesn't report who the members are, who the managers are. Let's open up a bank account in a friendly bank in Wyoming, and let's put a bunch of money in there, and we could begin to move money around and finance things. Nobody knows what the hell we're doing along the way. And if we don't put it in an interest-bearing account, there's no taxes to report because there's no income to report. So now so nobody knows who the hell we are. All right. We're funded with this money. Nobody knows where the hell it came from. And that could be used, really in the wrong way. So, and the other thing too is that, is we both know, we've both been on the planet long enough that, this is the Genesis legislation. Then they're going to start tinkering with it, and it may be 20 and 5 million, they become 10 and 2.5 million, and it could be everybody. We don't know where they're going to go with this. This is the opening salvo, and I think the opening salvo is miserable enough for many people, and there's a cost. So let's give you an example of what we do. So for all old companies, so to analyze a company, our firm, we're charging very nominal. We're charging $595 to do that. So the lawyer comes in, and it could be with anybody. It doesn't have to be our firm. Lawyer comes in and works with you to look at who are the owners, who are the controllers, what. Now you got to look at your estate planning documents, my God, to see who's the people that are involved there. It's just, the analysis is unbelievable. So we do that. It's almost as a service, because of $595, that's less than an hour. And sometimes these could take, some will be easy, some will be more difficult. And then we have a service that charges $250 to take, once the analysis is done and all the reporters are there, to get all the information from the reporters and file them with FinCEN and get the green flag. So you don't have to sit on the website for FinCEN and put in those 30 owners, and instruct them how to get FinCEN numbers and things like that. So basically, you're looking at maybe $850 round numbers for an entity. Someone's got 10 entities, it's $8,500. It's not a lot of money to spend to bring them all into compliance and make sure that it's that, and it's done under attorney-client privilege. And I think law firms are going to, and not every law firm could do that, because if they, divorce lawyers and lawyers, I don't know. There's got to be business-oriented asset protection estate planning lawyers that understand trust and understand business and business structures and ownerships and ESOPs and voting trusts and all those other things to make sure they're reported correctly. And that's another reason I think that you got a chance for unconstitutionality. The burden versus the benefit, it's just overwhelming. Yeah, Paul.
Yeah, I was going to say thank you. I mean, we're hitting it here. Great information. I want to thank everybody for being here. We are going to get the replay video out to everybody who registered, so look for that over the next few days. I want to say, Michael, thank you. We'll also send out
Michael,
contact
great to see you.
Yeah.
All right, buddy. Great to see you. Thank you also
everybody.
very, very much. Take care.
Okay.
Thanks.
Bye.
Thank you very much.
Welcome. Bye-bye.